Can somebody acknowledge they can hear me? Great. Good morning. We're in the record in case number 2020-00226, electronic application of Mount Olive Creek Solar, LLC, for a certificate of construction for an approximately 60 megawatt merchant electric solar generating facility in Russell County, Kentucky, pursuant to KRS Chapter 278-700 and 807 KAR 5110. My name is Kent Chandler. I'm the chairman of the Kentucky Public Service Commission and also serve as chairman for the Kentucky State Board on Electric Generation and Transmission Siting. I will be presiding over today's hearing. Joining me today via video conferencing, governor and ad hoc appointee. At this time, I would normally caution attendees to set your cellular phones to silent mode or turn them off. Due to the ongoing COVID-19 pandemic, the Siting Board is hosting this hearing via video conferencing. In addition to silencing your cell phones, I'd ask that you do the following. Please mute your microphones if you're not speaking. Attorneys, if interjecting, please state your name so the video record is clear. If you use a phone for audio and a computer for video, please turn off the computer audio, otherwise there will be feedback. Please use wired headphones or wired earbuds for better sound quality. Wired is also preferred because the wireless may lose power. Please keep a computer charger nearby if your computer battery runs low. And please alert the Siting Board if you're experiencing technology failure that prevents your participation at any time in the proceedings. Attorneys should contact Siting Board staff at the previously provided contact information. The hearing today is for the purpose of taking evidence on Mount Olive Creek Solar's application requesting a certificate of construction for a 60 megawatt merchant electric generating solar facility to be located in Russell County, Kentucky. At this time, we'll have an entry of appearance of counsel. I would also ask that when counsel makes their entry of appearance that they also present or identify the witnesses they'll have at today's hearing. For the applicant.
Good afternoon. Greg Dutton from the law firm Frost Brown Todd on behalf of the applicant Mount Olive Creek Solar LLC. I have with me today 4 witnesses: Carson Harkrader, Sully Van Meter, Dr. Coombs, and Ben Lindermeyer.
Okay. And for the Siting Board staff?
Cornelius Mance.
I've been advised that public notice has been given and filed into the record. Is that correct, Mr. Dutton?
That's correct, Your Honor.
Okay. And Mr. Mance, are there any outstanding motions other than the one for a deviation for setback?
No, sir.
Do you concur, Mr. Dutton? Is that the only outstanding motion that Mount Olive has?
There is at least one that was filed just about an hour ago for a motion for extension of time on the payment of the supplemental application fee. I believe that there may also be, the one for confidentiality was addressed. So I think it's just the motion for the extension of time and the motion for deviation.
Okay, we'll certainly review that other one, and I suspect, as has been the practice in the last few cases, the motion for deviation will most likely be addressed in the final order in the case.
Understood.
I believe that the public notice indicated the opportunity for public comments to be taken at this hearing, and I know that we have advertised as much on the website of the Kentucky Public Service Commission. Mr. Mance, has anybody signed up in order to provide public comments in this case?
There are none, Mr. Chairman.
Okay. As noted at the public meeting in this matter, if anybody would like to file written comments, they may do so at either the form or the email address listed on the Kentucky Public Service Commission website, which is psc.ky.gov. If there's nothing else, Mr. Dutton, if you don't have anything to present, otherwise you can call your first witness, please.
Thank you. Our first witness will be Carson Harkrader.
Ms. Harkrader, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
My name is Carson Harkrader. My work address is 400 West Main Street, Suite 503 in Durham, North Carolina, 27701.
All right, thank you. Mr. Dutton, you may ask, I just have the same request that we've had at all of our other hearings that we've had remotely over the last few months, that you ask the witness to identify what documents they have in front of them upon the tendering for cross-examination.
Will do, thank you. Ms. Harkrader, who do you work for?
I work for Carolina Solar Energy.
And what is your role with Carolina Solar?
I am the owner and the CEO.
And how long have you been in those positions?
I have worked for Carolina Solar Energy since 2012, and I have been the CEO and owner since 2018, so about 3.5 years.
Okay. And what was your role in this project, briefly?
I oversaw my team's work on the development of the project.
Is there anything in the record that you would like to correct or clarify?
There is one item. At the public hearing that the siting board held in Russell County earlier this month, Solly Van Meter, who will speak later, spoke with Glenn Shepard, who was an adjacent neighbor of the Mount Olive Creek project. And Mr. Shepard at that time told Solly that Mr. Shepard's home had been built immediately adjacent to Mr. Shepard's property line, which puts it immediately adjacent to the solar project. In our internal site design process, when we were preparing the siting board application, we had assumed that the building that is his home was a barn, and therefore we did not provide a 150-foot setback to his home. As we did, we provided that 50-foot setback to other residential homes that were near property lines around the project. Therefore, to remedy this new information, Mount Olive Creek will revise the site plan to show a 150-foot radius around the building that we now know is Mr. Shepard's residential home, and we will submit a revised site plan, and I apologize for that error.
Thank you for that clarification. Before we move on to the additional questions, can you give us, can you let us know what you have in front of you or what you're reviewing as part of your testimony?
Normally I would have the site plan open. I actually don't have the site plan open, so I just have my notes for what I'm talking about.
Thank you. Can you give us a brief overview of this project?
Sure, thank you. Good afternoon, Chairman Chandler and members of the siting board. Thank you very much for the opportunity to speak at this public hearing. I want to touch on a few points, and of course will be available for questions. My comments today are somewhat similar to the comments I made at earlier projects that Carolina Solar Energy has developed. We had the Horseshoe Bend project hearing in April and the Flat Run project hearing just recently. It's a pleasure to be here today. My team has put countless hours into this Mount Olive Creek project over the last 3 years. I'm very happy to be here to talk about it with you. To start out, I will explain my company's role in the project development. We are what we call an early stage project developer. And we made a decision about 3 years ago to start looking for new sites in Kentucky. We completed a number of early screens and had a few conversations with Kenya Stump at the energy office, the state energy office. From there, we identified a number of sites that passed our screens, and we started reaching out to landowners to see if they would be interested in having a solar project on their land. And we signed lease and purchase agreements for particular parcels that we felt were suitable for solar. And once we had enough parcels of land together for the size project that we thought would be appropriate in that location, we completed a number of other development steps, the most important and first being submitting an interconnection application to the utility, which is PJM and the East Kentucky Power Co-op. Then we were completing environmental due diligence, and later we worked with the local county to pass an industrial revenue bond and a pilot agreement. And we also created and submitted the siting board application that we will discuss today.
Have you and your company developed projects similar to this one?
Yes, we have. My company was founded by my father in 2004. And since then, Carolina Solar Energy has developed 45 projects that are in operation, about 500 megawatts of operating solar. Most of our operating sites are here in North Carolina, which is the #3 state in the country in installed solar. But we have developed 8 projects that are the same size as Mount Olive Creek that are in construction or operation. And most of those are in North Carolina, but there are 3 in Virginia as well. Our specialty is in choosing optimal sites for our projects, working with landowners, as I mentioned before, working with local communities, permitting, and title searches, surveys. We do all the work that is necessary to get a project ready to start to prepare to go into construction. And that scope of work typically requires a 2 to 3 year timeline, which is where we are now with Mount Olive Creek. So in Mount Olive Creek and the other projects we've developed that have been similar, we have completed the same scope of work.
And as you know, there's been a transfer of ownership of the Mount Olive Creek LLC. So does that mean that Carolina Solar will not construct this project?
Yes, that is correct. As I mentioned, our specialty is really working with landowners and communities and doing the early stage development work. My company does not build, own, and operate the projects that we have developed for the most part. The work will be done, the ownership and the construction and the financing will be completed by NG North America, who now owns Mount Olive Creek Solar LLC, which is the siting board applicant today.
And how did your company settle on the Mount Olive Creek location?
Yeah, so we did a lot of work looking at different power lines within the PJM and East Kentucky Power Co-op region and looking at different parcels of land. We look for areas that have reasonably flat topography and that are adjacent to power transmission lines that have capacity available for additions of solar. And so we settled on the location after locating a smallish number of parcels that had reasonably flat topography and completing an interconnection study internally that showed that we felt there was capacity for a project here.
And can you tell me a little about the initial public outreach when you were developing this project?
Yes, our initial public outreach was to our landowners, and fairly early in the process, my employee Chris Jones met with Judge Robertson. We really want to thank Judge Robertson for his work and assistance to us, providing us information on things we would need to know locally. His office has been very helpful as we've gotten to know him and worked on this project. Since there is no planning and zoning in Russell County, and so we did not complete a local planning and zoning process, but we did take the industrial revenue bond and associated pilot agreement to the Russell County Fiscal Court and asked for their approval for that, which they did approve, the pilot and the IRB, and so in that way they were able to review and learn about the project. Additionally, as we will outline today, for this project, the public outreach was a fairly extensive process. We really did a lot of proactive outreach in reaching out to adjacent neighbors of this particular project, and we'll talk about that a little bit more later.
I appreciate those comments, and with that, I will tend to the witness for further examination.
Mr. Mance, do you have any questions?
Yes, I have a few, Mr. Chairman. Ms. Harkrader, can you hear me clearly?
Yes.
I know you indicated that you might be that another party might be addressing this, but so please let me know if you're going to be passing this perhaps to Mr. Van Meter. But how many non-participating property owners are adjacent to the Mount Olive Creek facility?
To answer that question, I think that is reasonably easy to answer. Where I'm going to look is inside our application. Let's see. Okay. There is a, I think it's in the site assessment report. Yeah. Let me see. Yes. Attachment B to our site assessment report that was part of our application is a real estate impact study completed by Kirkland Appraisals. That is a 118-page report, And I'm going to scroll down and find out which page it is on. On page 4, there is a tax parcel map that shows the number of adjacent adjacent parcels. So on page 5 of that report, it details them, and there are 44 adjacent parcels. Now, a number of those adjacent parcels are owned by this, one person owns multiple adjacent parcels. Some of those adjacent parcels are also owned by our own participating landowners. So that does not give the number of non-participating adjacent landowners, but that gives the number of adjacent parcels.
Thank you. Has Mount Olive had any communication or contact with any of these adjacent property owners to discuss view shed or noise impacts, both during construction or operations?
Yes, and I will pass that question to Solly Van Meter, who was our community representative when Carolina Solar Energy owned Mount Olive Creek and remains the community representative. Yeah.
Okay. And I'll just ask the questions. You can advise me if you need to pass these on to Mr. Van Meter. Have there been any concerns raised by these adjacent property owners?
Yes, at this project site, we have had adjacent landowners. Some had questions and some had concerns. And some of those concerns we have been able to address and completely solve with them. As I think the siting board is aware, there is at least one adjacent landowner that, at least to our knowledge, did not feel satisfied by our efforts. And I'm referring to Cameron Tiller.
Okay. And has Mount Olive Creek committed to install any screening or other mitigation measures to reduce view shed or noise issues raised by these landowners?
Yes. There were different, I think your question has two parts. The first part, have we added landscapes buffering and vegetative screening? The answer is yes. There is vegetative screening along the highway that runs next to the site, the small highway, as well as in other parts of the site. For some adjacent landowners that had concerns, our work to answer their concerns involved other things other than installing vegetative screening. So kind of yes to both parts of your question, but we didn't solve every concern with vegetative screening.
And would you be able to go into any additional detail regarding the other mitigation measures you used or ways you addressed their concerns? Sure.
One of the very first things you do, if you look at, and I'm actually going to go ahead as Mr. Dutton asked me to say what I had in front of me, so I'm going to go ahead and pull up the Mount Olive Creek layout, which was attachment A to our site assessment report. I believe we have submitted a revised layout since that time, but that's the one I'm looking at. If you look at our layout, you can see on Sano Road, which is the road that kind of runs at an angle throughout the middle of the southern portion of the site, there are two parcels that are sort of surrounded, in effect, by the solar property. So two of the very first adjacent neighbors that we reached out to were those two landowners. The one that's almost right in the middle of the project, we spoke with those landowners, and their request to us was, please buy our home. We'd like to, we understand this project is likely going to go ahead. What would really work for us would be to purchase our home as part of the project. And so the project came to agreement with them on a price, and we have a purchase contract signed with them. And when the project goes into construction, the project will close on the purchase of their home, and the price they believe will be enough for them to build another home and purchase another property at another location where they choose to live. So that was one of the first major changes that we made to accommodate a neighbor. Another change we made, as you can see the location on the substation for anyone looking at the layout, there was a neighbor on the eastern side of the project that told us they were concerned because of the location of their home and the transmission lines. As we know, we cannot plant vegetative buffering under transmission lines in a transmission easement, and they were concerned that they were going to have a view of the substation from their home. And so we moved the substation a little bit further back on the property, within the property, to accommodate their visual request. So those were two of the early changes that we made to the site plan to accommodate comments that we received from neighbors. And I think Sally Van Meter will probably, if you would like, go into, each adjacent neighbor that we spoke with and what we did, but that's kind of an example.
Thank you. The siting board received multiple requests for a public meeting in this matter. Please discuss any community outreach done after submission of Mount Olive's application on May 27th of this year.
The formal thing that we did was to hold a public hearing or a public meeting in Russell County, specifically for the members of, there was a Facebook group started that was a Russell County Facebook group that was not specifically about this project. It was about utility scale solar in Russell County generally. And so myself and Linda Meyer, who's in this meeting, Sally Van Meter, and other expert witnesses participated in a public meeting to address the members of that specific group who had said that they needed more information about the project. So we held that meeting just about a month ago in Russell County. That was the sort of formal outreach effort that we made in this case. There may have been other individual outreach, but I think Sally Van Meter will go into more detail on that. And I believe information on that meeting that we held, informational meeting for the Facebook group, has been filed into the docket. So everything that was filed into the docket is correct as to my knowledge, and there's no updates about that particular meeting and that outreach.
Okay. Could you generally describe Carolina Solar's business philosophy as it relates to community outreach and how Carolina Solar interacts with the community where it's developed solar facilities in the past?
Yeah, solar is one of those areas where that saying about something about like a penny of prevention or a pound of cure. I'm not saying that saying correctly, but we definitely believe in doing early outreach in counties that have planning and zoning, where there will always be a public hearing. What our company does is to always do like a community dinner. We invite all the adjacent neighbors of the project to come meet with us, share a meal, and learn about the project in a meeting that we hold before the actual meeting that the Board of Commissioners or whatever it is in a county that has planning and zoning will hold. And so our philosophy is that that solar is new. Utility scale solar is something totally new. People are often going to have a lot of questions. They're going to want to understand what this technology is, what our company is, what we're doing, and that the best thing that we can do to help them understand solar, feel comfortable with the project, is to come meet them in person and to really have expert witnesses available that can share information. During COVID, we have not been able to hold those dinners that we typically would have had, and we would have had a dinner for this project, and we were not able to. One project in North Carolina recently, we've held a virtual public meeting, so we sent all the adjacent neighbors a coupon to the local barbecue place. They could go get their barbecue, sit down at their computer, and have a virtual meeting with us. So that's a new thing our company's been doing to try to engage even more, but we definitely feel that allowing people to ask us questions and get to know us early is extremely important. So that's if I could say our company philosophy in a nutshell, hopefully I said it pretty well.
All right. Thank you. I have no further questions for this witness.
Deputy Secretary Lyons, do you have any questions for Mrs. Harkrader? Excuse me.
No, Mr. Chair, I do not. Thank you.
Mr. Rowland, any questions?
No questions, Mr. Chairman.
Mr. Hoover, do you have any questions?
No questions, Mr. Chairman. Thank you.
And Judge Robertson, do you have any questions?
No questions, Mr. Chairman. Thank you.
Vice Chair Cubbage?
No questions.
Commissioner Butler?
No questions.
I have just a couple. I'd like to talk about the leases for a minute. I've tried to review as many of the lease documents that have been provided. Some of them, I think they're all identified as leases, but some of them are purchase agreements, and some of them are amendments to previous leases. So the first is kind of general. At least a few of the initial leases are with Carolina Solar LLC 3. And I think you're the signator on behalf of Carolina Solar LLC 3. Have all of the leases related to this project that were initially the counterparty, let's say, where the tenant was Carolina Solar LLC 3, have all of those leases been assigned to Mount Olive?
Yes.
Okay. And so I'll ask as a post-hearing data request, Mr. Mance, if you'll take note of this, for copies of the documents assigning all of those leases to Mount Olive. Second, as it relates to the leases, I know that there's a requirement in the lease, or at least one or two of the ones that I have reviewed, that indicate that there's a requirement at the end of or at the expiration of the agreement that the tenant will, well, let me take a step back. So I don't know if you're an attorney or not, Ms. Harkraker, and I'm not necessarily asking for a legal opinion, but is it your understanding, having been the signator, the person who signed on behalf of Carolina Solar LLC 3, the initial leases, that the assignments to Mount Olive that you just indicated have been filed, assigned all the rights and obligations under those leases to Mount Olive?
Yes.
Okay, so as it stands, and I think this is what the terms of the lease sort of indicate, is that upon assignment, as long as all the obligations are transferred, Carolina Solar LLC 3, at least per the terms of the lease, sort of, that their hands are clean in this situation. So it is Mount Olive that then steps into the shoes of the tenant. So with regards to the expiration of the lease, there's an indication that I just lost everybody's video. Can you at least still hear me?
Yes,
I
I can.
can. I lost everyone's video as well.
All right, so insofar as it relates to the expiration and the lease requirement, the land be put back effectively the way it was at the outset of the lease. There's that term, but there's no, as I can find it, there's no bond requirement in the lease or letter of credit that Mount Olive has to file in security. Is that your understanding as well?
That is correct.
Okay. And then separately, Mount Olive, though, has filed a decommissioning plan in this case. Is that your understanding as well?
That is my understanding. I believe NG North America filed that.
Okay. And the decommissioning plan refers to this idea that they will, the plan at least, is to, I think, well, let me just look at it so that I'm not, that there's a security filed pursuant to the decommissioning security determined by the decommissioning plan, and that effectively at a certain time following the operation of the facility, Mount Olive will create this decommissioning security in the form of either cash to be held in escrow or a letter of credit or surety bond from a financial institution, and effectively put it in the landowner's name, with the county being a secondary a secondary party or secondary beneficiary to those bonds. So I guess my question is it your understanding that although that's the plan, are you aware of any obligation by Mount Olive currently to file that decommissioning bond or that decommissioning security pursuant to any agreement that Mount Olive Creek has signed?
No, other than that filing in deciding board, there is no obligation either currently to my knowledge, at the Kentucky state level or at the county level.
Okay. And then one other item on the decommissioning plan. I just want to make sure that I'm aware. On the one of the first few pages, or I guess the first full page of the decommissioning plan, when it's discussing plan conditions, one of the items it says is that the decommissioning the project will allow the parcels that were changed under the project's approved conditional use permit to be returned to their original zone classifications. Are you aware of any conditional use permit that will be required by the county in this matter?
No, I'm guessing that was just kind of a typo, a remnant of an old plan. So
Okay.
Yeah.
All right. And I want to make sure I understand, do you have a map available to you of the property that indicates at least the residences in relation to the footprint of the project?
Mr. Chairman, can you clarify what you mean? Are you talking about the actual houses?
Yeah, that identifies the homes. There's at least a couple of maps in the case record that indicate like local homes. And the reason I'm asking is, and my entire computer has to reset itself, so I don't have it in front of me. But one of the reasons I ask is because there was a map that indicated there are two homes effectively that are in the center of the project. And the map I saw was the one that initially lays out or indicates the 150 feet radius, or I guess 150 foot circumference, radius, thank you. Radius from the homes to ensure that they're not within 150 feet of solar generating equipment like solar panels. There was one that had what looked like to be a home that did not indicate 150 feet. And then there was a separate residence, and I think it was identified as, here it is. It was a map provided in response to staff data request set 1, number 9.
Okay.
But there are two
Carson, do you have that in
homes.
front of you?
Mr. Chairman, I do want to note, sort of right in the very middle of the project, there is a residential home that has kind of a yellow dot right next to it. Are you looking at a site plan?
Hold on 1 second, I can tell you exactly what I'm looking at. As long as my computer does not reset itself again. So it's at item 1-9, and it's the Mount Olive Creek nearest noise receptors map is the one I'm specifically asking about here. But
Do you
there,
have the responses? I'm sorry, Mr. Chairman.
no, go ahead.
Carson, do you have the responses to our initial? Okay. Can
For
you?
Mount Olive Creek, that was, no, I do not have that saved in my file, so I
All right,
apologize.
Mr. Chairman, would it be all right if I shared my screen so that I think you're both looking at the same thing?
That'd be great.
Okay. Let me test this out here and see if I can do this correctly. Can everyone see this, the map?
We can. So my question.
Can you zoom it in a little, Greg?
I'm sorry, say again, Carson?
Oh, could you zoom it in a little bit?
I can't, yes. I can't see anyone, so you'll have to
That's great.
So this would be
Tell me
perfect
what you
here.
need.
So do you see resident C in the middle of the map?
Residency, yes.
Yeah. So, the following map, there's a map right after it that just gives a little more context. It notes that residence C is 115 feet from potential project footprint. Is residence C the residence in which Mount Olive has proposed to purchase the property?
No.
Okay.
But,
Are you aware of the general location of the property in which, the home in which Mount Olive has proposed to purchase?
yes.
Is it by any chance northwest along this line that's just below Residence C?
Would the second map show that, Carson? Here, if I can, Mr. Chairman, I've got another map open that will show this.
Well, I was going to say, if actually, Mr. Dutton, if you'll scroll down to the next set of responses, I think it's item 15 of that same data request, there's another map.
Okay. Yeah, I believe it's in the second set of responses as well.
Okay.
There's a clearer picture there.
So can you see that, Ms. Harkrader?
Yes. So the property that's right in the middle of the image with a yellow dot on
This
it.
one?
Yeah, I don't think we can see your mouse, Greg, but it's got a
Okay.
road. It's along Sano Road, and then it's also got a road. It's sort of at a T intersection.
Does it have a red roof
yeah.
there beside the yellow dot? Is that the property that Mount Olive has proposed to purchase?
Yes.
Okay, and so with that being said, is the 150 feet proposed for this site plan, or at least on this map, is that 150 feet from that home to the boundary of the property or to the nearest solar panel?
It's to the nearest solar panel.
Okay. And then, I guess I just want to make sure that the other part of this map that's beneficial here is the cemetery. And are you aware of the general location of the cemetery within the proposed site map?
Yes, it's actually shown on the screen right now, on Greg's screen, yes.
Okay. And it looks, it kind of looks like a darker green area that may be trees or whatever it is. How much of that space that is not taken up by solar panels in that area marked as the cemetery is actually the footprint of the cemetery?
I do not know how large the footprint of that cemetery is.
Let me ask this. The reason I ask is effectively my question is, do you know how far back from the edge of the cemetery that Mount Olive currently proposes to place solar panels?
I do not know that, and I'm not certain whether we put that into the application or not. But I do not know that off the top of my head.
Well, I guess I'll ask this question. Do you know if you all have determined how far away you've proposed panels, whether it's in the application or not, if you all have at least internally determined the distance you initially planned to place panels in relation to the cemetery?
No, I do not know.
Okay.
I apologize.
And you've been doing this since 2012. I know your father did this before. You've been around this for a while. Have you run into this before, in which there's a participating landowner who has leased the entirety of a property in which an actual cemetery is located?
Yes, we have. There are a couple of different general methods that Carolina Solar Energy and companies I've worked with have used with cemeteries. In a situation like this where the cemetery is fairly accessible to the road, we would typically just fence around the cemetery and leave an open entrance to the road so that anyone can come and go at any time. That is what we did propose here, is that there would be no fence blocking the entrance to the cemetery. Where there are examples where there's a cemetery that might be very far set back within a property, typically what steps that are taken would be to put a sign on the property and to say, if anyone would like access to the cemetery, please call this number, and then access is provided. Of course, we have spoken with our landowners to understand the history of the cemetery and whether they have knowledge of any locals or family members in general who they have seen, going to the cemetery, maintaining the cemetery, or just visiting the cemetery, which we did in this case. My recollection is that there is not a family that maintains the cemetery. That's my recollection. I'm not totally confident of that, though. I'd have to go back and do research and make sure that's the case. But I do know with this cemetery, the project's plan is to maintain open access so that there's a solar project entrance road there that remains open both into the solar project, and that there would be fencing around the panels, and that the cemetery would in fact have fencing all around it, but no gate or fence between the public road and the cemetery itself.
Okay. And that wasn't necessarily clear, especially with this map, because of the indication of where the fence is actually going to be located. The indication for the entry is covered by the yellow entry, the dot from the key for the entry.
Yeah.
And it's, I think the light color of I don't even know what year this would be, part of the year this would be, but whatever that is, light grass or wheat, I can't tell if the actual fence is proposed to go around that, or if it was proposed to be on the exterior, or if this map even reflected what the actual plan was.
Yeah, and if you would like, we could create a close-up map that would depict that in more detail. We can provide that.
So we'll seek that with a post-hearing data request, a more detailed map of what the plan is for, for entry and exit or egress to the cemetery, with at least an indication of the setbacks used for where the fence would be located in relation to the solar panels and the cemetery, and ensuring that the minimum distance from the NESC is complied with as well. And then the final question, Ms. Harkrader, since this determination, or this information gleaned from your conversations or Mr. Van Meter's conversations with Mr. Shepard a week or two ago at the public meeting, does the applicant expect that under the current footprint, that moving the panels to accommodate the 150 feet proposed setback from Mr. Shepard's home, that the current footprint has enough area to shift those panels and still maintain the 150 feet to a residence or noise receptor from the nearest solar panel?
Yes, we're able to make that change.
Okay. All right, those are all the questions I have. Thank you, Ms. Harkrader. Mr. Dutton, do you have any redirect the witness?
Give me just a second here, please, Mr. Chairman. I don't believe so, no.
Okay. All right, thank you very much. Is there any reason, Mr. Mance, that this witness can't be excused?
No, sir.
All right, thank you, Ms. Harkrader. Thank you.
Thank you.
Mr. Dutton, do you have an additional witness?
We certainly do. Next, we'd like to call Solomon Van Meter.
Mr. Van Meter, there you are on the screen. Make sure you turn on your microphone, and please raise your right hand. Do you swear and affirm that the testimony you're about to give is true and accurate under penalty of perjury?
I do.
Okay. Please state your name and address for the record.
My name is Solomon Van Meter. My work address is 450 Old Vine Street, Suite 300, Lexington, Kentucky, 40507.
Mr. Dutton, you may ask.
Excuse me, I'm trying not to sneeze right into the microphone. Okay. Mr. Van Meter, so who do you work for?
I work for Bowman Consulting.
And what is your role with that company?
My position is Senior Project Manager for Energy and Land Services.
How long have you been in that position?
I've been in that position for 3 months.
And how long have you been doing that type of work?
I've been doing that kind of work off and on for about 10 years.
And what was your role with this particular project?
I have done landowner relations and site acquisition. I've also done community and local government relations work.
And can you give us a general, excuse me, let me ask you one other thing. Before I continue, what documents do you have in front of you that you'd be reviewing during your testimony?
I have a map of the project site. I have my notes. I have the affidavit, or it's actually called a statement of certification that I filed several weeks ago about the informational forum. And I have another summary of the public engagement that we also filed in the docket in this case.
Thank you for that. Can you give us a general overview of public outreach made in this project?
Yeah. This project, Carolina Solar's normal public engagement at the early stage of development is pretty extensive. This particular project and some of the others that I've worked on with Carolina Solar have been stymied. That public outreach has been curtailed quite a bit by COVID, but I have been involved with this project for almost exactly 2 years, and this particular project has had quite a bit of communication back and forth with adjacent landowners and the neighbors, community, and with Judge Robertson and his fiscal court as well.
Thank you. With that, Your Honor, I'd like to introduce a map as Exhibit 1. I can, I believe, with your permission, share my screen and share the map.
That'd be fine. Is this the map that was shared with staff council earlier?
That is correct. All right, let's see if I can do this correctly here. Can everyone see that on their screen? It's extremely small on mine, so.
I want to blow it up just a tiny bit.
I don't think I'm seeing what you all are seeing, so that makes it tough. Can you see that?
I think we can see it fairly well.
Okay. Mr. Van Meer, can you explain what is depicted on this map?
Yes, this map shows the boundary of the project area in blue. It actually is, the blue outlines all of the parcels that are in the project. The white actually outlines where the project will be located, so because there are a few areas that are excluded. And then the green outlines all of the different parcels that Ms. Harkrader talked about that are adjacent parcels to the project area. The names you see on there, those are landowners that are adjacent landowners with whom we have had some kind of a personal contact, face-to-face meetings, telephone conversations, whatever, in this project, and that's quite a lot.
Did you create this map?
I did not. I did supervise its creation because I'm the one that's had most of the contact with these folks.
With that, I'd like to enter this into the record as Applicant's Exhibit 1.
All right. We'll mark that as applicant's Exhibit 1. We'll get you a copy of it, Candace. Thank you. Great.
Thank you. Did you participate? So you said that there were, I believe you said that there were 2 public meetings held in this case, and then there was the informational forum, and then there was the public meeting or public hearing organized by the siting board. So let me ask you about those first 2 public meetings. Did you participate in those first 2 public meetings?
I did. I should say I organized them and kind of got them together. If you remember, this was during COVID, and these are the meetings. What we're talking about now are the meetings that the meeting that is required after the notice of intent is filed, but before the application itself. And so That the first of those meetings was held, I'm going to refer to my notes, August the 6th of 2020, with the permission of the siting board. That was held virtually, but a physical attendance option was provided down there in Russell Springs. Subsequent to that hearing, a parcel or two were added to the project area, and so we noticed a second public hearing, which again, with the permission of the siting board, we offered a physical attendance option only if anybody signed up for it, and no one did. So that second public meeting, pre-application, post-letter of intent, or notice of intent, was held strictly virtually. The recordings of those, I believe, are posted, I believe are in the docket of this case.
So these the green outlines on this exhibit, are those the landowners that would have received notice for those public meetings?
Yes, they would have received a letter by certified mail and regular mail about the project, and then, of course, the public meetings were also advertised in the local paper, or,
Okay.
notice of.
And to your knowledge, the record of those meetings has already been filed into the docket into this matter, correct?
Correct.
Okay, so let me ask you now about the informational forum. Can you explain how that came about?
Yeah, I'll try. It's in I guess in April of this year, and I was, in June of this year, I was contacted by Judge Robertson, who informed me that Mr. Cameron Tiller had come to visit him in his office, and then had also subsequently appeared during the public comment section of the April Russell County Fiscal Court hearing, and expressed concerns about the project, and also his desire for some more information about it. And Judge Robertson requested that I go meet with him, which I thought was a great idea, and did, with the support of NG and Carolina Solar, who, I think they considered that a great opportunity for further outreach. I went to meet with Mr. Tiller at his home. He was quite hospitable. We visited for about an hour, and I offered up the opportunity for NG and Carolina Solar to bring experts in and answer the questions that he might have, or that members of his Facebook group might have. And that's how it came to happen. It was NG and Carolina Solar taking the suggestion of Judge Robertson, and then kind of turning it into an opportunity.
And who attended that informational forum on behalf of the applicant?
I'm going to refer to the certificate, the affidavit that I filed, if I may. Marty Marchterry of Copperhead Consulting, Chris Sandifer, an engineer who has had his career at Duke Energy, Rich Kirkland, a real estate expert whose report is filed in the record in this case, Ben Lindemeyer from NG North America, Matt Mooney, also from NG North America, Carson Harkrader, and I attended that myself.
Okay. And the majority of those individuals flew in from someplace else, is that correct? They weren't located there locally, is that correct?
Everybody but me.
And who attended the informational forum with questions?
I take that back. Marty is from Kentucky, and Copperhead Consulting is over in Paint Lick, Kentucky. I stand corrected. Ask your question again, I'm sorry.
That's all right. And who attended the informational forum with actual questions for the applicant?
Mr. Tiller was there, and Sierra and Trinity Coffee, a couple that owns property on the north side of the project area, also attended.
And can you summarize the communications that were had during that forum?
They stayed quite a while, and I think that they asked every kind of question about the project that you could think of. And I believe it did turn into a great opportunity. We had people there that could really answer the questions authoritatively and provide them the information that they were looking for.
I appreciate that. So let me move on to the public meeting that was held in Jamestown. So obviously the siting board and its staff are aware of who attended the public meeting, but just as a refresher, can you remind us of who made comments at that meeting down in Jamestown?
Mr. Tiller appeared, and Glenn Shepard, another neighbor of the project, briefly appeared as well.
And did you have communications with either of them following the meeting?
I had talked to Mr. Tiller quite a bit before that, but I really haven't talked to him at all since then. Mr. Shepard, I did have talked to quite a bit since then. Immediately following the hearing, Mr. Shepard and I, he showed me on the map where exactly his home is located. That's where we learned of our mistake about the fact that that was his home and not a barn. I've had ongoing conversations with him, not daily, but pretty close since then, as we've tried to do things with him to alleviate his concerns. Certainly the 150-foot setback, the adjustment of the panels away from his home will be the largest, the most important piece of that.
Do you have anything in the record that you need to clarify or correct at this time?
I do not.
And with that, I will attend to the witness for additional questions.
Mr. Mance, do you have any questions for Mr. Van Meter?
I believe he addressed the follow-up that I had for him. So no, Mr. Chairman.
Mr. Dutton may make it a little easier on us. Well, let's leave it up just in case, since it was the basis for both of the direct examination, the exhibit you have. Mr. Rowland, do you have any questions for Mr. Van Meter?
I do not have any questions, Mr. Chairman.
Trying to think, Mr. Lyons has left. Mr. Hoover, do you have any questions for the witness?
I do not, Mr. Chairman. Thank you.
Judge Robertson?
The only thing I have is, I talked to Mr. Van Meter, but I'm going to deal with some, I guess, along Sano Road. I was concerned, I had some concerns of what kind of blockage or whatever, something to prevent sight distance on the solar panels along the Sano Road before you get to the cemetery that we were talking about earlier.
Yes. Judge Robertson has been kind of invaluable in guiding me in my relations with the neighbors in this case. And most recently, we talked about the screening along Sano Road, particularly on the western end of the project. And there is this project has got really good existing tree line screening for a whole lot of it, but that's a part where it's more open. And this isn't, of course, the site plan, but Judge Robertson asked for assurances that that adequate screening along that would be put in place. I believe the site plan shows that, but NG has committed to making sure that end of the project has plenty of screening along it. Is that what you're asking, Judge Robertson?
Yes, sir. That was my concern. Thank you.
Yep.
Vice Chair, do you have any questions?
Yes, just one. Good afternoon, Mr. Van Meter.
Hey.
The Oaks parcel, the one that's basically surrounded by the project,
Yes.
have they indicated that they're satisfied with the amount of screening that's been proposed?
They have. That's an interesting parcel. The Oaks don't actually live there. They live to the north of this. Their property, I think, is underneath the label there for Sierra Coffee. Up there at the top of the page. Their home is right up in there someplace. But this little postage stamp of a property is the place where their mother lived, and their parents are buried there. So this is, although it has a small kind of trailer home on it, which they have a tenant that lives there, I think rent-free. The primary concern the primary use of this property for the Oaks is essentially sort of a really tiny family cemetery. And so they were, I've talked to Jonathan Oaks. Jonathan Oaks also happens to be the county extension agent for Russell County. And great guy. But anyway, we've talked quite a bit about the screening, and offered even to do, some kind of ornamental fencing or whatever to make the cemetery function of this property more of a, more attractive. And that they haven't insisted on any of that, but I expect that as the project gets ready to go, we'll do something more like that for them.
That's all I've got. Thanks.
Okay, Commissioner Butler?
No, the vice chair asked my question. Thank you.
Mr. Van Meter, I don't know who to ask this question to, and I'm always worried about dismissing a witness and then finding out that that's the witness I needed to ask a question of. So I'm going to start with you, and we'll go down the line, and thankfully Ms. Harkrader hasn't left yet, but I don't think it'll be her that has the answer. As I'm sure you're aware, you've done a few of these cases now, that there's a provision in the citing board statutes, I think it's 278-706 sub 2 sub K, that specifically references whether the applicant or anyone who owns an interest in the applicant has any violations or alleged violations of state or federal environmental laws. And the application, the indication was that the answer to that question was in the negative, that neither Mount Olive nor any of the entities that own an interest in Mount Olive have, been alleged to or actually found to have violated any of those environmental laws. Since then, we've gotten a notice of transfer in this case, in which now there are new entities that own an interest in Mount Olive. Do you know whether an update to that question has been filed into the record, or the answer to that question, whether any of the entities that currently have an interest in the facility or in the applicant would be answered any differently than it was in the application?
I do not know the answer to that.
Okay. Do you know who might know the answer to that?
To my understanding, the only entity that owns an interest in Mount Olive Creek is NG North America.
Okay.
Or a subsidiary of its. And so I would think that would be the place that I would start looking.
All right. I appreciate it. Mr. Dutton, do you have any redirect, Mr. Van Meter?
I do not. Thank you.
Okay. All right. Thank you, Mr. Van Meter. Yes, you can step down even though you're still sitting.
Thank you, Your Honor.
Yeah. Mr. Dutton, you may call your next witness.
Yes, our next witness will be Dr. Paul Coombs.
All right, Mr. Coombs, please raise your right hand and turn on your microphone. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Paul Coombs, 3604 Trail Ridge Road, Louisville, Kentucky, 40241.
Thank you, Mr. Coombs. Mr. Dutton, you may ask.
Dr. Coombs, who do you work for?
I'm just a sole proprietor, consulting economist.
And how long have you been doing that?
I've been doing consulting off and on for over 35 years.
Have you done other jobs during that time?
Yes, so I'm an emeritus professor of economics from University of Louisville. I was a professor there for almost 30 years. Did consulting off and on there, but although mainly I was a university contract person. And since I retired from the university, I'm doing more consulting.
And what was your role with this particular project?
So Carolina Solar contacted me a little over a year ago about several of these solar farm projects coming to Kentucky and asked me to develop a methodology for estimating the economic impact on the region, the county, whatever's relevant. And so I think this is the third one where I put together a short, simple statement on the expected economic impact in the county or the region.
Is there anything in the record that you would like to correct or clarify?
No, I think it's still accurate.
And can I ask you what sort of documents or information do you have in front of you that you may be referring to during your testimony?
Yeah, I just have the May report that I wrote for Carolina Solar, which I'm sure is in the record. And then there's a document from the Public Service Commission with a set of questions. I think that was in June. I've got that here and just a notepad, so that's all I have.
Thank you for that. With that, I will attend to the witness for further questioning.
Mr. Mance, do you have any questions for Mr. Coombs?
No questions for Mr. Coombs.
Mr. Rowland, any questions?
Yes, Mr. Coombs, and I apologize, I just have your work that's attached to that application in front of me right now. Can you hear me?
There was a little feedback, but I can hear you.
I was getting that as well. In your report, there was an attachment to the application. You just analyzed the potential for jobs created during the construction phase, is that correct?
That's true, although there's a mention of the 2 or 3 likely ongoing jobs, which is so small we didn't pay a lot of attention to it.
Okay, I was just curious as to what analysis you did for the recurring annual jobs after the construction period, but I just wanted to make sure I wasn't missing anything. Okay, that's the only question I had. Thank you, Mr. Chairman.
Mr. Hoover, any questions? Mr. Hoover, can you hear us?
Yes, Mr. Chairman, I'm sorry. No, I do not have any questions.
All right, thank you very much. Judge Robertson?
One question, does your report show any anticipated land value changes with this project?
To the extent, I did cite the pilot payments that you all, I think, have agreed to now, and it amounts to, I think, about $1.42 million over 40 years, which works out to a little over $40,000 a year in payments to local jurisdictions in lieu of taxes. And looking at some of the spreadsheet data that Carolina Solar's provided, where they listed the current landowners on these parcels and the amount of property taxes being paid annually, I think it amounted to a little less than $4,000 a year. So, I think that's a relevant point, that this development will end up generating about 10 times the tax revenues to local government and school districts and other jurisdictions as under the current use of the land. Is that your question, sir?
That was part of it, and also the real estate value of nearby adjoining properties. Do you have
Oh,
any?
no, I did not. I think the real estate appraiser may have, Carson can address that. I think the real estate appraiser, Kirkland, addressed that in his report, but no, I didn't do any real estate analysis.
Okay, thank you.
Vice Chair, do you have any questions?
No questions.
Commissioner Butler, any questions?
No questions.
I just have one very small line of questioning, Mr. Coons, and it's around, I guess, the methodology and the inputs. Certainly other places in the United States have had a lot more solar development than Kentucky over the years. I think that may be an understatement. The largest solar facility we have in the state is 10 megawatts, built a handful of years ago by LG and KU, basically being co-located with other generation. We've got approximately 28 projects that have either actually filed applications with the siting board or have filed notices for applications, with another 100 approximately in either the PJM, MISO, TVA, or LG and KU transmission queues. Certainly not all that 100 will find its way in front of us, but the reason I ask is it's my understanding that whether it's through a JEDI model or whatever you use, they're fairly, whatever you're, I'll say it this way. My understanding is that the models you're using include, generic may be the wrong word, right? But not necessarily specific inputs that are based off of previous experiences with this type of project in these exact locations. And frankly, because I guess that would be impossible, right? Because we don't have anything that's happened prior. My question is, given that with that being the case, is there an expectation that as time goes on, we'll have more specific data to use in these types of economic models to determine not necessarily were they accurate to begin with, but that we have more detailed economic information for projects that come in 4 or 5 or 6 years, down the road, based off of what we've actually seen from these initial projects?
Yes, sir. That's a great question, and I really appreciate that. The model, the JEDI is an interface that is developed in the industry to pass information, investor-related information along to these input-output models, which I did use. M-Plan is the most widely used one in the world, and so that's what we used here. Thankfully, there is a sector in the model. There's 500 different industrial sectors in the model, and the one called New Power Structures actually has populated data that we could use to simulate this. It's not broken out solar, it just says New Power Structures. When you get to the operation side, however, the operation of a solar farm, the cells are all empty, and they're empty for every county in the state. I have data for all 120 Kentucky counties and for the state total. All of those cells are empty for just the reasons you pointed out. There's no historical data to populate those cells. As these projects come online, M-Plan will then see data coming through the federal statistical system on employment and payroll and activity in these sectors, and they'll start populating those cells, and then, we'll get some refinements of these estimates. Now, as you probably noticed in my report, the predicted spinoff impacts are pretty modest. We only go from about 150 direct construction jobs to a little less than 200 total jobs in the county. That's not a large impact by the standards of economic development projects, but that's what the model predicts. To check that, because we don't have a lot of history here in Kentucky, I did compare that to a very elaborate set of studies out of California where they looked at the amount of construction spin-off over 6 different large solar farm projects out there where they had very good accounting data. And it gave me great comfort to plug those numbers into this 60-watt project and found that it predicted 144 direct construction jobs, whereas Engie and Carolina Solar and I, our best estimate was 150 direct construction jobs. So that was very close and gave me comfort that, we're in the ballpark on this project. And of course, nobody knows exactly how many, and nobody will until the project's over because the contractor has not let all the subcontracts yet.
So,
Does that answer your question? Or
it does. It does. It leads to the 2 follow-on. The first is there any way to actually go back and check the accuracy of these types of models after a certain number of years, or is it just impossible given the number of variables to do it effectively after the fact but-for test?
Another great question, and it's very expensive to do that. There have been some studies published in the academic literature, excuse me, where researchers will go in and try to line up ex post accounting data to what models predicted. And I don't have an example off the top of my head, but I used to publish in this literature quite a bit. And I can tell you that these models, like M-Plan, are considered relatively accurate, given that they run on secondary data and a lot of assumptions. So, I mean, the answer is it's the best tool. These are the best tools we have, given the data, and we don't have a big brother that makes everybody release all their proprietary data. So researchers like me do not have access to the actual proprietary information. We have to run on these models, which in the literature are considered very reliable.
And then finally, I guess the one thing that I don't necessarily understand the output of the model or your data is the durability of the carry-on or the follow-on jobs. You were talking about it. The estimated construction jobs are 150, but the follow-on economic impact could lead to total 200. Does the model look at the durability of those, or is it a snapshot of time, 1, 2, 3 years after construction, or is that an average over the life of the project? I'm just curious what that 200 actually represents.
Yeah, another great question. So that is a one-time, 1-year impact. So that is assuming this project takes about a year to build out. Those are the related jobs through the supply chain, some of which will be met by local suppliers in Russell County, combined with the impact of construction employee spending in the area on restaurants and car dealerships and those kind of things, all within the time frame of 1 year. So those are not continuing jobs at all. That is the construction impact. We don't expect more than a handful of jobs, for maintenance and ongoing operations.
Okay. All right. Thank you very much, Dr. Coombs. Mr. Dutton, do you have any redirect for Mr. Coombs, Dr. Coombs?
I do not. Thank you, Mr. Chairman.
Okay. All right. Thank you. You may be excused. Do you have one more witness, Mr. Dutton?
I do. Just one more witness. I'd like to call Mr. Ben Lindermeyer.
Mr. Lindemeyer, please unmute your microphone and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
My name is Benjamin Lindemeyer. My work address is 1360 Post Oak Boulevard, Suite 400 in Houston, Texas, 77056.
Mr. Dutton, you may ask.
Mr. Lindemeyer, who do you work for?
I work for Engie North America.
And what is your role with Engie?
I'm a director of project development.
How long have you been in that position?
For a little more than 2 years, and in similar functions for about 10 years.
Okay, and briefly, what was your role in this project?
So NG is taking over development of the Creek Solar Project, and I'll be coordinating internally with internal and external specialists on engineering, construction preparation, support the financing, and of course, complete any outstanding environmental or permitting work.
Is there anything in the record that you would like to correct or clarify?
Nothing to my knowledge, in addition to what Mrs. Hartwright already commented on.
And can you tell us what records or documents you have in front of you that you'll be reviewing while you testify today?
I have the PSC website open, so I have access to everything that has been filed. I have my personal notes, and I do have a quick memo on environmental impacts in front of me.
And can you tell us generally about NG's experience with solar projects?
Yeah, NG is obviously a very old company, about 200 years old, a very large group. It's in fact the largest independent power producer worldwide. Has a power generation fleet of about 101 gigawatts globally, which is about 2,000 of Mount Olive Creek solar projects, basically. Main generation is solar, wind, and gas. In the U.S., NG has been operating for about 45 years. North American headquarters is in Houston, Texas. And we currently operate about 4 gigawatts, 4,000 megawatts of solar and wind projects. And we do have about 10 gigawatts in development. NG has partnered with Carolina Solar on a number of projects. Some are in construction. First one has actually gone operational, most of them in North Carolina and Virginia. And we are now partnering on a few Kentucky projects as well, and Mount Olive Creek is one of them.
And does NG intend to construct and operate this project?
That is correct. NG develops, finances, designs the projects. NG markets the power, and we operate the project. We oversee and monitor construction, but NG itself is not a construction company, so that will be outsourced to specialized solar construction companies.
Thank you for that. With that, I will attend to this witness for further examination.
Mr. Mance, do you have any questions for Mr. Lindemeyer?
Yes, Your Honor. Mr. Lindmeyer, if you refer to Mount Olive Creek solar responses to the board's consultant report, specifically responses to recommendations A1 and A2 regarding the site development plan, in each Mount Olive Creek advises that the site layout has not been finalized and contractors have not been selected, and the possibility exists that minor changes to the site layout may occur. Mount Olive then recommends that alterations to the site layout that do not impact compliance with setback requirements be considered immaterial changes that will not require siting board review. Regarding this request, may I first would like to ask, do you know when the site layout will be finalized?
We are in very early stages of preliminary engineering, but the site layout will not be finalized until about third quarter of 2022, since the project is scheduled to go into construction either end of 2022 or early 2023. So probably a full year out till final site plan is known and finalized.
And when do you expect the contractors or the independent solar construction companies to be selected?
I would assume first quarter of next year, potentially as late as second quarter. Very dynamic environment. But obviously talking to previous contractors and contractors we have relationships with already, but might happen as late as second quarter next year.
Have any changes been made to the project boundaries since the initial layout filed May 7th of this year? And supplemental information filed on May 24th of this year?
Not that I'm aware of.
Are you aware of any changes that are currently expected to be made to the preliminary site plan dated June 28th, 2021 that provide a response to the first data request?
Not that I'm aware of.
Are you aware of any changes that are currently expected to be made to the preliminary site plan dated June 28th, 2021 that provide a response to the first data request?
Not that I'm aware of. I'm not currently aware of any changes that have been made, but as you mentioned, the design is not finalized, so going forward, changes will be made, yes.
And specifically regarding those changes, are there any changes that need to be, are you aware of any changes that need to be made to the vegetative buffers or array of setbacks after you had the public hearing?
Not to my knowledge, no.
If changes were to occur to the site development plan, is the project expected to expand or shrink in size?
It is my experience and my understanding also of the process that once permitted, the project cannot expand. So if there was a change happening, it would be shrinkage, also made or potentially feasible by development in panels and advanced technology. For example, increasing panel wattage would allow us to deploy a lower number of panels, which would then allow us to reduce the footprint. But equipment has not been selected either, so at this point, I'm going to say I don't expect any significant changes.
Is the applicant aware that any change in plans will need to be submitted to the siting board and may require a motion to approve the changes?
To a certain extent there, Your Honor, I have to object because I think that's calling for a legal analysis and decision, which I'm not sure that this witness is actually qualified to make.
I guess I'll ask it this way, Mr. Dutton. Does the company have a preconceived idea of what it currently anticipates doing absent some direction from the siting board? I think that's the premise of Mr. Mance's question.
I have to admit, I'm a little bit confused about the question.
That's fine.
Still.
Mr. Mance, would you like to ask it again?
Yes, I'll just rephrase here. Regarding any potential changes, would NG expect to first approach the siting board regarding any specific changes to the actual something that be beyond trivial changes to the general plan design?
Let me ask this, Mr. Lindemeyer. You know the site plan that's proposed. And I think there's an anticipation, I think it's only reasonable to expect that won't be down to the inch the exact layout that eventually gets built, if approved. Do you all have an expectation today of the type of change that you would currently, in the site plan, that you would currently expect to bring back to the siting board?
I'm sorry, are you asking theoretically, or are you saying, do you expect that you'll have to come back?
No, I'm asking, is there an internal threshold by which you say, if we're asking to move the panels closer to a home, well, we know that we would have to get approval for that because it would be contradictory to, a siting board order, right? The order says it can't be within 500 feet of X, and we're proposing to move something 500 feet. I guess my question is, if you're going to go out, I think what Mr. Mance is asking is, let me say it this way, Mr. Dutton. I'm going to take a big step back here. This is not a question. This is a statement from Kent Chandler and from nobody else. We have a process in place, right? We have an applicant in these cases. Questions are asked from staff, from the siting board members. We get a consultant's report in which the consultant has mitigation recommendations, right? I've always read that as being some sort of meeting of the minds as to what the expectations of the siting board and the consultant are going to be in the eyes of the applicant, right? Understanding eventually what is expected of them in order to go forward. I think the question is, based off the idea that the applicant in this case has said, we will come back if there's any significant change from the planned, what is it exactly called? The
Site layout.
the site layout, right? I think we're trying to understand as a siting board what that means from your all's perspective, since that's your all's position, so that I think there's a meeting of the minds, and there may or may not be reason to further define what that requirement to come back for approval might be. Does that make sense?
It does. I would have, so let me say this. I would object to the extent that I think there's a little bit of a legal question, sort of is the foundation for what you're looking for. But at the same time, if Mr. Lindermeyer can respond to that as Mr. Lindermeyer, not NG in North America, then I think that's a question that he could certainly try and answer.
Yeah, so let me ask Mr. Mance, the applicant has stated that they intend, if there are certain, is the word material or significant changes to the site plan, that they intend to come back for siting board approval, is that correct?
If they want the certain changes, if they don't impact compliance with setback requirements, to be considered immaterial.
Okay. So the question that I would have for you, Mr. Lindemeyer, is that the only threshold in your mind at that point in which you all anticipate coming back for approval, is an actual change to those setbacks? Is that the only thing in your mind at this point that would require that, so that we can take that under advisement, determining what mitigation measures may be necessary for this case?
There's a few layers to my response. Obviously, we will adhere to all conditions of the board, or that the board implements on the project. As we talked about, there will be changes to the project overall. There will be changes in equipment selection. There will be changes in arrangement of modules and inverters in the project. If there is a condition that defines setbacks of equipment to residences of the project footprint, then we will obviously adhere to those. If there is any reason why that would technically not be possible, and I don't foresee one right now, then obviously we would follow protocol and process to get board's approval for that.
So let me ask this question, Mr. Lindemeyer, and this may help Mr. Dutton with his concern around the legal opinion. I think is this in response to the consultant's report?
Yes.
Yeah. So my question for clarification on this would be from this perspective, that I can read the response as being one of two things. As being either a statement seeking clarity around the idea that if we're going to move things closer to a home or to a structure or to any point, closer than an order requires, we agree we should have to come back and ask for that because it's material. But the statement can be read in another way, in which that it's the applicant's proposal that the only material amendment to the site layout that would have to require additional siting board approval is if the change results in any of the facilities being closer than the setbacks are required by an order. And the reason that I seek the clarification if it's one or the other of those is because, and this is an extreme hypothetical, but I think it underlies why I need clarification. My understanding is that these are proposed to be on, steel structures that are, 4 to 6 feet off the ground. If the applicant all of a sudden proposes to build these 14 feet off the ground so that cattle can graze underneath them, I would argue that although they're not moving any closer to a home, that's certainly a material change to the proposed site plan. And so I just ask if you could clarify what it is that the response is intended to indicate. And if you're not the correct witness, that's fine. If you'd prefer to answer this in a post-hearing. But the question that I have, I don't know if Mr. Mance is trying to get to this point or not, is it the company's proposal that the only change to the proposed site plan that would require additional siting board approval is moving any of the facilities closer than they will be ordered to if approved?
But your question is obviously, or your example is obviously an extreme one, and personally, I would see that as almost, as a significant alteration to technology if we're suddenly exceeding height restrictions and building much larger structures. So I would almost say that the change in setbacks would not be the only significant change. But since the lion's share of the discussion was about the setbacks, hence our response that we would obviously adhere to the setback requirements, and it would be most changes moving equipment within the footprint and outside proposed setbacks would be immaterial, as opposed to encroaching into setbacks that have been imposed upon the project, which would then constitute a material change.
Okay. Mr. Mance, you can continue, unless Mr. Dutton has additional concerns.
I don't. I may want to follow up on redirect.
Thank you. Referring to Mount Olive Creek solar responses to the board consultant report, specifically responses to recommendation A5, Mount Olive Creek advises that the minor variations in construction schedule and workforce estimates may occur, and in turn recommends that minor alterations to the construction schedule and workforce estimates be considered immaterial changes that will not require siting board review. When speaking to the construction schedule, are you referring purely to the days of the week and the times during the day when the construction will be allowed? Or are you including the expected length of the project's construction?
I'm really referring to the sequence and duration of the project construction, because at this early stage of the project, you usually assume basically a best guess or standard construction timeline, which might change based on various external factors, the size of the contractor you sign up, the number of staff they will deploy, the urgency to get the project online because the power is marketed, or the need to push construction start back because of permitting delays, or just various factors. So it's mainly the duration.
Okay. What would you consider as a minor change to the construction schedule and workforce estimates?
I think right now we're assuming about 1 year construction. It can fairly easily be compressed to 9 months, or if the construction is extended to a year and 3 months, that's also within the range of normal events with construction. So anything along those lines, basically.
Okay. Refer to Mount Olive Creek solar responses to board's consultant report, specifically responds to a recommendation A9 in regards to the cemetery and along Sano Road. Mount Olive Creek states, access to the cemetery will be maintained throughout the life of the project for those wishing to visit the cemetery. Could you describe in detail how Mount Olive Creek will ensure access to the cemetery during construction and during operation?
Usually, that's not the first cemetery we have encountered on the solar project, and usually what happens, the fence is, I call it, lollipopped around the cemetery, So there is an entrance road or entrance path that's wide enough for pedestrians or sometimes even vehicle access. And then the fence is wrapped around the known perimeter of the cemetery and basically brought back to the road. So it's basically carved out of the solar project. So it has open access. Or another alternative is, I think Ms. Hartbraden mentioned it earlier, contact information on the fence where people willing to visit the cemetery would reach out to the construction manager, to the site operations manager, and request access.
Referring to Malala Creek solar responses to the consultant report, specifically response to recommendation B3 regarding compatibility with scenic surroundings. Malala Creek states that it is happy to discuss concerns and potential mitigation measures with any project neighbors harboring concerns, and that it will offer additional vegetative screening where logistically feasible and not in conflict with construction and operational requirements, advising vegetative screening cannot be necessarily be added to all project locations. What project locations are you registering where vegetative screening cannot be added?
I'd have to look into that in detail if there is a location where it cannot be added, or, but I'd have to look into that.
And in general, and then I would ask a more general question, are there particular sections in which vegetative screening cannot be added that you may already, that you've encountered in past jobs? Particular general areas of a site?
Well, the general area where you obviously cannot plant any vegetation is if you have power lines crossing the project or running along roads, because obviously those easements are owned by other third parties that have requirements to maintain their right-of-way open. So that's what would prevent us from planting vegetation. But it's my understanding that on Mount Olive Creek, there is a lot of intact and existing vegetation on the site already.
Have you been involved in addressing any concerns from any existing neighbors regarding that were unable to be addressed by vegetative screening?
I was part of the public information event that Mr. Van Meter spoke about earlier, but I'm not aware of any concerns that have been left unaddressed or any major existing concerns. We're in ongoing conversation with Mr. Shepard, as Mr. Van Meter mentioned earlier, but it's my understanding that all concerns related to the solar project and visual impacts have been addressed. Obviously, there are always general concerns about a solar project being a solar project that we will never be able to address regardless of the number of public hearings.
All right. Referring to the your responses to the board consultant report, specifically response to recommendation B9 regarding anti-glare panels and minimization of glare. Mount Olive Creek argues that it is unreasonable to require the facility to cease operations based on the complaint of a potentially one person traveling near the facility. Could you explain why the requirement is unreasonable when Mount Olive Creek has committed to operating panels in a way that minimizes and eliminates the glare?
So solar panels are obviously produced with the single goal to absorb solar rays and not reflected, because any reflection of light is obviously lost to the solar project or to the electricity generation. So just the panel technology itself already provides for maximum absorption of light, and also the project is, I think from a layout perspective, is mainly, the panels are mainly facing east and west and going to follow the sun, and the main roads surrounding the Mount Olive Creek solar project are more in the northeast direction. So I don't think there will be much glare coming off site, but it's also, as you mentioned, it's is it possible for the solar project to cease operation upon individual complaints of glare coming off the project? Because obviously it's hard to verify and it's highly objective.
And just to continue along that thought process, what steps would Malala Creek, if there are concerns regarding glare, what steps would Malala Creek take to address the concerns?
We'd obviously have to have experts looking into that and determine what exactly causes a glare, to which time of the day, maybe a certain position of the sun at a certain time of the day causes that. And then, if possible, we try to increase buffering, vegetative screening in that position of the site, so that that particular location where the glare was observed would be shielded better.
And my final question will be, we've heard regarding Carolina Solar's general approach to its business philosophy as it relates to community outreach and how it interacts with the community to address concerns. Could you provide a general explanation of the business philosophy of NG and how it addresses concerns with the public to address any concerns raised during the operation of the project or during construction?
Yeah, obviously, approach is very similar to Carolina Solar Energy, is that we want to be a good neighbor, and we want to bring benefits to the community that we build solar projects or any projects, and wind projects, solar projects, small solar projects as well. And you want to keep the neighbors happy. You want to be perceived as beneficial to the location and not as a detriment or a nuisance or annoyance. And also, globally speaking, obviously, NG is a publicly traded company, so we're very interested to keep a good public image and to not, quite frankly, not have any bad press around any projects not operating to the liking of the neighbors and of the community.
And I actually do have one additional question, or I do have two additional questions. Regarding the motion for deviation, section B1 regarding noise, you indicate that construction activities are anticipated to be transient in nature and are limited duration, ending once construction has been completed and taking place during the hours of 7 a.m. to 9 p.m. But also in your more recent response to the consulting report, you stated that you were aware of the recent decisions where the siting board limits hours of construction to 8 a.m. to 6 p.m. Monday through Saturday. Is Malala Creek committed to maintaining those working hours?
Yes, we've seen those on previous projects, and I think that is acceptable to the project. If limited further, that would obviously be a large detriment to the project, but I think 8 to 6 would be agreeable.
And I have a final question regarding decommissioning. Just a question regarding the filing of bond. Are there plans, does NG currently have as part of their official decommissioning plan, plans to file bond with the county?
Yes, on solar projects, we post decommissioning bonds to provide security to counterparties that the necessary financial wherewithal is in place to decommission the facility. So either be the county or landowners. Usually it's the county as the authority being part of that bond.
And at what stage of the project do you file that bond?
Usually, there's different approaches. Usually, we file it either before construction start, or since the project is very valuable in the beginning of the operations phase. We also had authorities requesting it be filed after 10 years and then revisited after every fifth year.
Thank you. I have no further questions, Mr. Chairman.
Judge Robertson, do you have any questions?
Yes, sir. I've got one question. in regards to the construction companies that'll be doing this work for Mount Olive, will y'all require them to have any type of surety bonds to pay for any damages done to county roads? There are several county roads that are going to be encompassed in this project.
Absolutely. NG has extensive insurance requirements to all companies it works with. So absolutely, insurance will be in place.
Okay, thank you.
Mr. Rowland, any questions?
No questions, Mr. Chairman.
Vice Chair Covich?
Yeah, just a few. Good afternoon, Mr. Lindermeyer. It's good to see you again. Are you the right person to talk to about PJM interconnection?
I'll try my best.
Okay. Do you know if the application to interconnect to PJM has been approved yet?
The project is still in the study phase, so we've received several studies, but the interconnection service agreement is not executed.
Okay. And this is on page 26 of the interconnection study report that was submitted with the application. And I don't expect you to have it in front of you, but it indicates that an LG&E affected system study would be required because of some tie line overloads on the connection between East Kentucky Power and LG&E. Do you know if that study has been completed yet?
I am very confident that study has been completed. I might have project merged in my head, but I think the one I looked at 1 days ago was actually from Olive Creek. And it resulted in no effects.
Okay. And I only have one other question, which is good because I'm starting to get some feedback and it's a little hard to understand you. Do you know if any analysis of endangered or threatened species have been done?
Yeah, absolutely. We conduct studies for every project, and we look into endangered and threatened species. For this project, it's my understanding that bats have been brought up as a concern by many interested people, and we do have an environmental consultant on board who has looked into that in particular. And as tree clearing will be required on site, a bat plan and a logging plan will be prepared and will be filed with Fish and Wildlife, Department of Fish and Wildlife Resources as well. And just to make sure to reduce impacts on endangered wildlife as much as possible.
Okay, that's all I've got, Chairman. Thank you, Mr. Lindermeyer.
Thank you.
Commissioner Butler, any questions?
No questions at this time.
Mr. Lindemeyer, as part of the application, the statute requires under KRS Chapter 278, 706, sub 2, sub K, that the applicant provide a detailed listing of all violations by it or any person with any ownership interest of federal or state environmental laws, rules, or administrative regulations, whether judicial or administrative, where violations have resulted in criminal convictions or civil or administrative fines exceeding $5,000. The status of any pending action, whether judicial or administrative, shall also be submitted. At the time the application was filed in compliance with that requirement, the response, I guess, to that requirement was that neither Mount Olive Creek Solar LLC nor any entity with ownership interest in the project has violated any state or federal environmental laws or regulations. There are no pending actions against Mount Olive Solar Creek LLC nor any entity with ownership interest in the project. Do you know, given the transfer from Carolina Solar L3 LLC to NG, the NG subsidiary, whether or not that response has changed or needs to be updated?
Is my audio back to acceptable before I answer? Yeah, all right, perfect. That's a difficult question because, as I mentioned, Engie is 200 years old and it has about 160,000 employees globally. So I don't know off the top of my head. I'd be hopeful that there is nothing, but I can certainly try to verify that with our legal departments.
I appreciate it. And the reason I ask it is because I didn't necessarily expect you to have the answer, but it gives me an opportunity to file a post-hearing data request seeking an update to that so that you have an opportunity to go back and find that out. Are you aware of how Engie in North America has treated decommissioning bonds in other jurisdictions?
Treated in the sense of most of the decommissioning bonds in other jurisdictions, yes.
Yeah, so, okay, well, and let me, that's a very unfair question to ask. Let me ask it this way. I have an expectation that, as in this case, Engie North America as a single tax entity, taxable entity or single organization entity, that the holding company or the ultimate company probably doesn't individually own all these projects. There's probably a certain level, like in this case, where the actual energy projects are owned by a subsequent entity, such as Mount Olive LLC owns these, right? So with that being said, my understanding is also that, especially with solar facilities, Mount Olive Solar may go its entire life, if approved and built and operated, without ever actually employing a single person, right? NG may, on Mount Olive's behalf, employ people to operate it or whatever it is, but the entity itself may not have employees or agents, right? It may contract for certain items. And its assets, as I understand it, are effectively the leases, right? Or a purchase power agreement, something like that. Those items related, related specifically to this project. There aren't going to be these other assets. So my understanding, and correct me if I'm wrong, is that Mount Olive Creek may not necessarily be the entity or the only signator of a bond, right? That an ultimate parent company may, enter into a bond on behalf of and named in addition to Mount Olive and other subsidiaries. So my question is, do you know how that relationship works? Who actually goes out and gets the letter of credit? Who actually does the work for the decommissioning bond? Who makes sure that the payment is completed, is reviewed? Are there additional signatories to make sure that it's, ultimately cheaper from a more creditworthy entity? Is it done on behalf of multiple entities? I'm just curious if you have any knowledge of that from the NG North America perspective as to how that's treated in other jurisdictions or for other projects.
Mr. Chairman, I appreciate the sort of explanation there. I do want to object to the extent that there were a couple of statements in there that are not supported by the facts and the record, but to the extent that Mr. Lindermeyer understands the question, I would invite him to go ahead and answer.
I'll just answer the part of the question that I believe I understood. So the physical work is obviously done by NG employees. That is correct. I'm not an insurance expert, but Mount Olive Creek will be party to the bond, which is an insurance product. It's not necessarily relevant how many assets that entity or the entity pulling that insurance owns. I'm not sure, or I can't speak to whether there is an underlying agreement between an upstream NG entity and the insurance providing that bond. But for the decommissioning, Mount Olive Creek will be party to that decommissioning bond. And since it's an insurance product, that insurance will be in place and valid as long as the premium is paid, which is happening before the bond is issued. So that makes it a very, very safe tool.
Okay, so a couple things, but the primary one is under the proposed decommissioning plan, At which point under that plan does NG anticipate filing a decommissioning bond or letter of credit?
That depends on the authority issuing the requirement. I've seen it early, meaning prior to issuing a building permit. I've also seen it after a certain amount of years, 10 years, 15 years, whenever the authority believes that the asset's value might have decreased and it would warrant for decommissioning security to be in place.
Well, but are you aware of any entity that currently requires Mount Olive to have a decommissioning bond in place today?
No, I'm not aware of one.
Okay, so Mount Olive Creek proposed this plan, right? And I'm asking, under the proposed plan, when do you propose for the decommissioning bond to go into place?
I'd have to go back and look through the decommissioning plan and see what exactly the proposed point in time was.
Okay, so do you have an anticipation with your proposed decommissioning plan as to how long the bond will be? Is it for the length of the proposed project, or is it for those time periods prior to review? So as I understand it, there's supposed to be a periodic time period in which the amount of the bond is reviewed, something like 5 years maybe. Is that your understanding?
Do you need to look at the decommissioning plan?
Can you repeat that, please?
Yeah, do you have the decommissioning plan in front of you? Would that help?
I do have it in front of me, yeah.
Okay. Mr. Chairman, to the extent that you can refer to sections of the decommissioning plan, that may help the witness answer some of these questions.
I can,
So
quote the decommissioning plan here real quick, section 3.2, security. It says decommissioning security shall be provided by Mount Olive Creek Solar within 30 days following the 20th anniversary of commercial operation date.
Okay, so that's what I was getting to earlier, if you knew that. So it's being proposed, your proposed plan is that the bond goes into effect, and I think it's necessarily a bond or a letter of credit, but the bond goes into effect, we'll call it the security, goes into effect after 20 years in operation, right?
That is correct, and the reason for that is that the power is marketed, the contractual or a power purchase agreement, which is obviously an offtake contract for a significant duration. So the asset is worth a lot more than decommissioning would ever cost. And even if the project value goes down due to depreciation or reduced output over time, what I'm used to seeing is that the remaining equipment value still exceeds the decommissioning cost, especially with the current development of steel price and the steep inclines in steel cost and raw material cost. That usually outweighs the full decommissioning cost for the project.
Does NG have a PPA for this project?
We're in negotiations for this project and others, but no agreement executed at this point, and I cannot speak to details about the offtake.
And that's fine, but I just asked because you referenced, the asset of having a PPA. But the solar facilities can participate in electricity markets such as PJM's capacity and energy market without a purchase power agreement, right?
They can or they can?
They can, correct?
It's my understanding that they could, yes.
Okay, and there's a day-ahead and a real-time energy market. Are you aware of that?
I'm not an expert here, but the project is definitely seeking a contractual offtake with a likely corporate offtaker. So there are certain auxiliary services in the market that will contribute to the overall economics, but the main target is a corporate power purchase agreement.
Okay. So it says in the second half of that security paragraph that you referenced earlier that per methodology outlined in 3.1, Mount Olive Creek Solar LLC shall update the decommissioning cost every 5 years, estimate every 5 years, following year 20 after the commercial operation date until project site control agreements expire or terminate. And my question is, do you know if this is a term of a bond? If you are going to enter into a bond for a certain length of time, or if you intend on entering into 5-year bond terms and then just getting a new security each time it's updated?
I don't know off the top of my head, frankly. Again, because I'm not intimately familiar with bond terms. It's my understanding that a bond is basically evergreen as long as it's reviewed every year. It seems, or renewed and repaid every year. So that 5-year term, I think, was just based on re-evaluating market labor costs and steel commodity prices, steel prices, was not necessarily linked to a bond duration.
The reason I ask these questions, Mr. Lindenmeyer, and this is not necessarily a question, but effectively because you asked, is that I take no issue with NG's creditworthiness. The fact of the matter is that this is an LLC and can be sold fairly easily, right? And should NG, as creditworthy as it is, intend on, helping support such a security, a decommissioning security like a letter of credit or a bond, I think that would probably make everybody much more comfortable. The reality is, though, that it's NG's. It's your asset. You can do with it as you like, and you could certainly sell it in 3, 5, or 30 years should you like. And I don't know that we necessarily will know who. If it requires an additional counterparty, in addition to Mount Olive, an additional counterparty to a decommissioning security like that, who that next entity will be. And so that's why I asked the questions as to how that actually works in relation to the ultimate parent companies or the entities that have an ownership interest in Mount Olive, if they are involved at all in that decommissioning security process. So it's my understanding from your responses that that's not necessarily your expertise, is how NG is involved in setting up that bonding for its subsidiaries like Mount Olive. Is that correct?
That comes back to my initial statement that the solar project, due to the contracted output, is at all times worth a lot more money than the decommissioning cost. So at any point in the project life, that would always far exceed the decommissioning cost, let alone the bond cost, which is a small percentage of the total decommissioning cost. And even if the project would not generate any output, which is highly unlikely because that would assume that all modules are taken off or the wires cut, the remaining scrap value of the installed equipment would again always exceed at least the cost to post the bond. So regardless of who posts that bond or who has a relationship with insurance, that bond is a standalone insurance product that the project entity will enter into, pay for, and be party to, and that bond will hence always be in place for a fairly small amount of money.
So you're just effectively arguing because it's your understanding that historically, even if it's useless for in terms of creating electricity, generating electricity, that because its net salvage is positive, it's a fairly immaterial issue whether there's security available in the form of a bond or letter of credit?
That is correct, and I actually worked on projects in my past life where the permitting agency did not even require a bond because they saw estimates from a state licensed engineer who clearly confirmed that the scrap value will always be higher than the decommissioning cost.
And was that in the United States?
That was in the United States.
Do you know what jurisdiction?
That was in Virginia.
Okay, I appreciate it. Do you know what state agency that might have been?
That was the county.
Okay. All right, thank you very much, Mr. Lindenmeyer. Mr. Dutton, do you have any redirect to Mr. Lindenmeyer?
I do. I have a few items, Mr. Lindenmeyer. Mr. Lindenmeyer, you doing all right? You need a break?
I'm good, thank you.
Okay. So a couple of follow-up items that were touched on earlier. One was the cemetery. A couple of things about it. My understanding is that the owner of the cemetery is a participating landowner. Is that correct?
That is correct.
And there have been discussions with him well in advance of today about the access to the cemetery and sort of how the cemetery is going to be treated in terms of project construction and site layout.
Correct.
And those discussions are essentially going to be ongoing through the construction phase. Is that correct?
Correct.
There was a question about site layout and whether or not there would be changes to it. So I want to explore a couple of aspects of that. We have talked, I believe, since the site layout plan was filed, and there are likely to be at least 2 changes to it since the site layout plan was filed. The first is to accommodate the 150-foot buffer around Mr. Shepherd's house. Is that correct?
Yes, that's correct.
And then there was an acknowledgement and agreement that there was going to be some additional vegetative buffering placed along certain portions of Sano Road. Is that correct?
That's correct as well.
Thank you. And then, if I can, let me ask you if you have this in front of you. It is the, I believe it's the siting board application. Let me get to the right place here. This may be actually the site assessment report. Yes, so this is the site assessment report. Do you have that in front of you, Mr. Lindenmeyer?
I'm pulling it up right now.
Okay, let me know when you've got it.
Can you point me to the page?
Yes, page 2.
Oh, okay.
Are you there?
Yep.
So I'm looking at particularly paragraph 4. So paragraph 4 discusses the preliminary site layout, and then it lists preliminary plan that shows following items that will not materially change during final design. And if you scroll down to the top of page 3, it talks about the applicant proposed that any material changes in the above items would require approval, and then the items below would not require approval. Does NG still stand by that statement in terms of what would require a revisiting to the siting board? Take your time to review.
I'm afraid I'm not looking at the same document you're looking at because my number 4 says something differently.
Okay, so I'm looking at the site assessment report, which was filed in conjunction with the application.
Yeah.
And
Section.
I'm looking at page 2, paragraph 4.
Okay, apologies. I was looking at PDF page 4, not document page 4. Okay.
So it's document page 2. I guess it's PDF page 4, paragraph 4. 4 into 5.
Yeah, and those A through G, that's, we still stand by the statement that those will not materially change, yes.
Okay, thank you. Just a moment, Mr. Chairman. Those are all my redirect questions. Thank you.
All right, thank you, Mr. Lindemeyer. You may step down or sit down. Whatever works in the context of a virtual hearing. Do you have any additional witnesses, Mr. Dutton?
I do not. That was our final witness.
Okay. And do you have anything else to bring to the citing board on this case?
I don't believe so, no. I believe there are the two pending motions. We talked about that at the beginning, but I believe those are the only outstanding issues.
Yeah, I've had a chance just quickly to review the one you filed walking in, and we'll try to address that in a timely manner, but I think that you got to give us a couple days maybe.
Certainly.
And then, as I said, I think the other, our past practice has been to address that in the final order. Mr. Mance, is there anything else that we need to take up today?
No, sir.
Okay. And I think that we'll have a couple of post-hearing, not near as many as this morning, a couple post-hearing data requests. Can we have those out by tomorrow?
Yes.
Okay. And I have, Mr. Dutton, that the case, a final order in this case must be entered by November the 3rd. Is that your understanding?
That is my understanding as well.
Okay. And as I noted this morning, of course, you have the opportunity to file a brief if you would choose to do so pursuant to the regulations. We can't really set the time on that. Our hands are tied. But how much time do you need to respond to the post-hearing data request that we'll issue tomorrow? Let me ask this, Mr. Dutton. This morning, we set a date in which those hearing requests will be filed on October the 12th. Would that also work?
Yeah, if that will give the citing board enough time to review them and produce its order, then yeah, that should work just fine.
Okay. So they'll be asked by the end of the day tomorrow and responded to by the end of the day on October the 12th.
Excellent. Thank you.
All right. Hearing nothing else, this hearing will be adjourned.
Thank you all very much for your time today.